Good morning. Thank you all for joining us today. My name is Matan Shacham. I'm joined by Kat Shu, and we are going to be talking about generative AI. And specifically, we're going to be talking about two aspects of it. Our presentation is going to be sort of split down the middle. The first half of the presentation, we want to talk to you about the latest developments in AI litigation. There's obviously a lot of that going on right now. We're doing a lot of that work here at KVP. It's very much sort of a growing and developing field. So we want to give you the latest on that. And then in the back half of the presentation, we're going to talk about the sort of ethical issues involved with using AI as a lawyer. So that'll be our presentation. Without further ado, I'm going to turn it over to Kat, who's going to start with the updates in litigation.
Thank you so much, Matan, and it's great to be able to see everyone here today. As a bit of background, as Matan said, I'm an associate here at KVP, and in a prior life, I was an AI product manager at Google. So it's fun to be able to see some of this Gen AI developments from the other side. The first thing we did in this presentation, of course, was to ask ChatGPT what the top 3 legal and generative AI developments were in 2025 and 2026. And I think it actually did pretty well. So generative AI copyright lawsuits, the development of the EU AI Act, and also courts sanctioning lawyers for AI hallucinated citations. And here's an image that ChatGPT also generated on these 3 topics. As Matan said, we'll start with a very brief introduction to what AI and Gen AI is. We're going to talk through some of the significant AI regulations, both in the States, in California, and also abroad. We'll talk through the major developments in private litigation, especially highlighting major opinions and settlements that have happened in the past year. And then also, I'll hand it back to Matan, who will talk about using AI in legal practice and the ethical considerations to keep in mind there. So very, very quickly, generative AI is a subdivision of artificial intelligence, which is really just a fancy word for math and statistics to predict, what is the best next word or what is an image that would most match someone's description in a prompt. And generative AI is just a subset of that, specifically relating to generating new text or generating new images or sound or video using those learned statistical concepts. And this is just a very simple diagram of how large language models might work. So, for example, you have a lot of text learned from your training examples, which could include, books or other types of training data. You learn relationships about what types of words tend to appear next to or after other types of words. And then when a user asks you to generate that data, you take the probabilities you've learned and then you try to figure out what the best next word is. So for example, Paris is a city in France is the most common and most popular word that comes next. But you also see the, for example, it could be Paris is a city in the south of France, or I think it's in the north of France. So you can see those statistical relationships that are learned there. And if you had to really break it down into 3 steps, there's really just 3 simple steps to LLMs, which is gathering data, so collecting a large amount of text data from different sources to teach the model about language, using computers and servers to teach the model to learn these parameters, and then ultimately deploying and improving. So putting the model to use, gathering more data, and being able to fine tune it for better performance.
It'll be like, the proposal to NIAD, here's what we need for an end of phase 2 meeting.
Can we ask the participants to please
Put
mute?
some thought into it. We're not asking NIAD. Yeah, so anyways, I think we're agreeing that we would benefit on both sides from spelling that out, like you have been.
Excuse me, I think there's someone who
I don't
needs to
think there will be any pushback
mute their audio, please.
from him because
Name
he's
is
already done
Donald.
that. And it's
Donald
just,
is
we're
speaking.
just spelling it out. That's all.
They push back.
Amy, is it possible to mute? Oh, great. Thank you so much. That sounds more interesting than what I'm talking about now. So in terms of diffusion models, which relate to images, there is a very sort of physics-related concept, which is what it's named after, which describes how molecules move from high concentration to low concentration areas. And diffusion models draw upon that concept by trying to add noise to a model, to an image randomly, and then remove that noise to create a new image, and sometimes based upon a text prompt as well. So this is what you see here, sort of adding random noise and then teaching the model how to remove that noise in order to generate a new image. This is a vast oversimplification of what actually happens, but this is sort of the core of a lot of the image models that we see today. Next, we're going to talk through significant AI regulations, starting with the United States. The answer here is that there is currently no comprehensive federal legislation that require the development of AI or specifically prohibit or restrict their use. That being said, there are a bunch of different bills, I think over 100 bills that have been introduced in Congress that cover issues such as AI education, copyright disclosure, AI robocalls, biological risks, and AI's role in national security that are being considered. And most of these proposed bills sort of emphasize the development of voluntary guidelines and best practices rather than set a hard line for what's permissible or not. And generally, I think lawmakers have taken a pretty cautious approach to regulation aimed at fostering innovation without imposing strict mandates. And there's a lot of concerns about stifling technological progress and trying to maintain competitiveness against countries such as China. We also see here that in Canada, there has been efforts to pass such a comprehensive AI policy called the Artificial Intelligence and Data Act. But unfortunately, it has failed to pass and would need to be introduced again in order to come into effect. And that policy was a high impact system risk policy that aimed to regulate especially high risk models pertaining to areas such as education and healthcare and law enforcement, where AI would have the biggest impact. And then setting a series of best practices to ensure that those models are transparent and accountable, and that they are providing notices of possible harms. In California, there is similarly no large comprehensive AI law, but there's almost 24 AI-focused laws that have either already come into effect or just become operative in 2026. So in California, we actually have a standardized definition of artificial intelligence, which is engineered or machine-based systems that varies in its level of autonomy and that can infer from the input it receives how to generate outputs that can influence physical or virtual environments. There's also a patchwork of different laws regulating different areas of AI that are perceived to be high risk. So for example, regulating voice and likeness AIs, such as digital replicas, including when replicas are made of someone who is deceased. There are laws focused on election integrity, mainly aimed at deceptive advertising and political communications. So making sure that political campaign materials that are AI generated are labeled as such. And then platform transparency focuses on making sure that training data for various models and AI generated content is properly identified. And we also have various consumer privacy and sexual exploitation protection laws that require consumers to be protected and for generative AI to not be put toward child sex trafficking and other uses. Generally, these laws have been met with success, but there are also laws that have been vetoed, especially those targeting what we call frontier models, which are models that are at the cutting edge. So what you think of as, Google's models or OpenAI models that are a certain size. And one bill that was vetoed was SB 1047, which would target the most resource intensive models in California, and that has not passed so far. Various other states have also implemented different pieces of AI regulation. For example, in Colorado and Texas and New York, there are more comprehensive AI regulations that regulate high-risk AI and provide various avenues for governance. Some of these other states, such as Utah, Illinois, Tennessee, and Washington, have narrower AI-specific laws. Utah passed an AI Policy Act, which requires disclosure when consumers interact with generative AI. Illinois has the longstanding BIPA, or Biometric Information Privacy Act, and various AI hiring laws. And we'll talk a little bit more about lawsuits brought under BIPA in a couple slides. Tennessee has recently passed an Elvis Act, which protects voice and likeness from unauthorized AI. And Washington, like California, has deepfake election laws and various biometric privacy rules. The most comprehensive act and an act that serves as a model for many of these regulations that we've talked about is the EU AI Act, which takes a risk-based approach to AI. It prohibits certain AI uses altogether, such as using AI to manipulate people or exploit vulnerabilities. And it also defines certain high-risk AI settings, such as healthcare, transportation, and law enforcement. And so the EU Act has been in effect for a while now, and it's been staged in terms of its rollout. And while we haven't seen major enforcement actions or penalties based on it, we do expect to see those upcoming soon. Another country that has put in place AI regulations is China, with a focus on generative AI, deep synthesis, and a recent new act on anthropomorphic AI, so AIs that simulate humans either in chat or video format that are perceived as high risk. Moving back to the question of US law and US regulations in particular, recently we've seen some movement in the Copyright Office in terms of offering guidance to creators about what is copyrightable. And it seems like what the Copyright Office and various courts have landed on is that substantial human input to final work is still necessary in order to make a work copyrightable. So that can include editing or arranging of output elements. And one example of this is the Zarya of the Dawn case, where Zarya of the Dawn referred to the use of Midjourney to generate images for a comic book called Zarya of the Dawn. And the Copyright Office refused to register these works that were generated by an image generation service called Midjourney. And it found that text prompts, even ones that were pretty detailed, were not sufficient for human authorship because the output is unpredictable and not completely controlled by the artist. And the Copyright Office has since, in its guidance, reaffirmed that view. And recently, the DC Circuit has held that the Copyright Act requires all eligible work to be authored in the first instance by a human being. And that requires more than just prompting an AI. The Supreme Court was somewhat expected to take this case, but it didn't. So that ruling in the DC Circuit is final for now. There have also been executive actions relating to AI, and many of these, especially in this administration, have related to making sure that AI is competitive, removing barriers to AI, so removing guardrails in terms of risk assessments and disclosure needed. One key highlight is, I think, on one of the first days of the administration, President Trump issued Executive Order 14179, which rolled back one of President Biden's, 14178, which rolled back Biden's executive order on AI development, with the goal of ensuring that AI can be developed quickly and competitively, and in order to compete with some of these other countries. President Biden has also issued an executive order on ensuring a national policy framework for artificial intelligence, which involves, challenging state laws that have policies that are not in line with the federal view of AI development. And I think that was just issued in December of 2025. So we haven't seen any challenges under that law yet, under the executive order yet, but that could be incoming soon. The bulk of the presentation will now, move into these private litigation developments. As we have seen, there aren't, big regulatory frameworks or laws. And so a lot of law is currently being made in the courts. And as many of you are likely aware, in the past year or so, there have been a significant uptick in the number of private suits filed against AI companies. And a lot of these suits raise novel legal questions, such as what data can be used to train generative AI models? How is the data used? What kind of outputs do the model create? And how does the law apply to the models and outputs? And they're being brought on a different range of legal grounds, ranging from copyright to trademark dilution to breach of contract and invasion of privacy. And these suits are likely to continue to grow without clear federal or state guidance. So in the next few slides, we'll take a look at some of these cases, some of the interesting questions raised by them, and some of the insights that we can glean from these early court decisions. And I'll caveat that plaintiffs usually raise a mix of these issues in their suits, but we'll focus on just one topic at a time. This is a chart, I think, from late 2024, so this is slightly out of date, of the types of lawsuits that have arisen in the copyright context. So more than a dozen AI copyright suits, and I'm sure more now, have been filed across the country. And the center of this litigation is primarily in the Northern District of California and in the Southern District of New York. So what do these cases look like? So far, the plaintiffs tend to be fiction and nonfiction authors, comedians, politicians, artists, cartoonists, and photographers, as well as publishers like the New York Times and Thomson Reuters, and music groups like the Universal Music Group. The suits are generally directed at AI companies, and plaintiffs are typically pleading both direct copyright infringement and secondary liability. And as you can see, nearly every major generative AI company has been pulled into this legal fight, including OpenAI, Meta, Microsoft, Google, Anthropic, and NVIDIA. So there are a few theories that plaintiffs typically advance for direct copyright infringement. First is a training-based theory, so alleging that the AI companies violated their copyrights by training their models on copies of plaintiffs' works, whether that be photos or videos or text. And then other theories have focused on outputs. So they're saying, hey, you generated something that looks exactly like my work, which follows a reproduction theory of copyright. And there has also been a derivative work theory that has been somewhat rejected by courts. For example, Judge Chabria rejected that theory in saying that, passing your work through a model and then generating, using many other images and the statistical relationships learned through those images doesn't amount to creating a derivative work in the output. So that's a third theory that has fallen a bit out of favor. There have been two major opinions in the copyright context, and I'm not going to go too deep into these because there is a session focused on trends in copyright. But these two opinions are extremely important and will shape and have shaped the litigation in the copyright context. And before I dive into these two cases, I'll talk a little bit about the concept of fair use, which is a defense to copyright infringement. And basically, there are a variety of factors, four factors that courts assess to determine whether use of a copyrighted work is fair. But I'll focus on the first and fourth factors, which courts have found to be most important. The first factor relates to transformativeness. So is this use of this work transformative such that the purpose of the end product was not the same as the purpose of the initial work that was alleged to be copyrighted? And the fourth factor is market harm. So did, the output of your AI model cause artists or authors to actually lose market share, or did it create a new market that didn't actually relate to the initial art or text or book markets at issue? So in Bartz versus Anthropic, a case in the Northern District of California, the court held that training on copyrighted books can be fair use. However, using books that were pirated did not amount to fair use. And based on that, the court certified a class that consisted of the authors that were in these copyrighted pirated data sets. And Anthropic, seeing this decision, later settled for about $1.5 billion. But this approach isn't necessarily the only approach, as we saw in Cadre versus Meta Platforms in Northern District of California as well. A district judge, Judge Chabria, held there that while training can be fair use, proof of market harm can actually sort of swing things the other way. He pointed out that in this case in particular, there wasn't sufficient evidence to see that the market for plaintiffs' works was actually harmed, but explicitly reserved and said that if there were more evidence of that presented, then the fair use decision might actually come out to be the other way. And so, this is the framework that we have for some of these ongoing cases against OpenAI, for example, which KVP represents for training based on text. And then there are additional cases pending for Stability AI, Runway, which KVP also represents, DeviantArt, and Midjourney relating to image training and videos. And then there are a few pending cases relating to music training as well, based on apps that generate new music. The next area of litigation that has seen especially a big uptick in the past year or so is litigation under the Digital Millennium Copyright Act, or DMCA. And there are a couple provisions of the DMCA that are usually at issue here. The first is the anti-circumvention provision, which is commonly cited in the scraping context. So the statute says that no person shall circumvent a technological measure that effectively controls access to a work. And that can include, for example, bypassing a CAPTCHA or bypassing a restriction under preventing different IP addresses from accessing the website, and then scraping data off of a website after getting through that gate. There are also DMCA Act claims under 1201 or 1202B1 and 3, which relate to copyright content management information, or CMI. And this relates to different companies allegedly removing the CMI from images or text, and then using that as training data, and then producing producing images without the CMI attached. So this is an example of what CMI actually looks like. So that can include the title of the work, the copyright notice, etc. And courts have been somewhat mixed on whether removal of CMI, whether removing CMI and using that as training data can violate this provision. In Cadre, the case we talked about before, the court found no liability if the training was fair use. But in one of the OpenAI cases, the court declined to dismiss the claim because the plaintiffs have plausibly alleged that OpenAI distributed complete copies of the work with CMI removed. The most challenging piece of the CMI inquiry tends to be the scienter requirement, because it's not just about removing and distributing. It's about knowingly removing the content and then knowing that it will induce or enable an infringement of rights under the Copyright Act. So that has been a general challenge in the courts. There are also a few scraping, so based on the anti-circumvention provision of the DMCA, cases that are ongoing. We haven't gotten a big decision in any one of these cases yet, but especially as it relates to scraping websites. But there have been some cases that involve downloading YouTube files behind the YouTube video that courts have found to constitute circumvention of the protections put up by YouTube to prevent you from doing that. I actually didn't know that you could download YouTube videos at all, but there's a way to do so by putting in various parameters into the URL. And this issue is pending appeal in the Second Circuit in a case called Ute. Another ongoing case is a case against Perplexity AI, which is an AI company that is alleged to have used services or used tools that have scraped Google, and specifically the Reddit content on Google. And KVP is currently representing Perplexity in that case, and it's currently at the motion to dismiss stage. So no major opinion has come out of that yet. Another big category of cases are these trademark cases. And some claims have survived the motion to dismiss stage. So it shows that some of these claims may have bite. But these claims typically involve, as you can see on the right side here, a generated image that has a Getty Images watermark as well. And in a Getty Images case, the company is alleged to have diluted the brand by putting Getty Images logos on generated images that may be weird, like someone losing an arm, for example, and having that. You've all seen that sort of happen with generative AI photos, as well as a likelihood of confusion theory, like someone looking at this image might think that it came from Getty, as when it didn't. But because of various jurisdictional issues, that case was dismissed, and then it has recently just been refiled. So we haven't seen too many developments on that front either. There have also been a recent wave of right of publicity cases. This case in particular involves Kyland Young, who is a reality TV star on shows like Big Brother, who filed a complaint in the Central District of California. And he alleged that this software company called Neocortex violated California's right of publicity statute because it allowed users to face swap with various celebrities. So you could face swap with Frida Kahlo, you could face swap with Johnny Depp, you could also face swap with Kyland Young, sort of without his permission. And he alleged that they used his identity to solicit the purchase of paid subscriptions. The company moved to dismiss, and the court denied that, and the Ninth Circuit affirmed, and the case has since been dismissed. But this isn't the only right of publicity case. We've also seen threatened lawsuits from Scarlett Johansson, for example, who alleged that OpenAI, in an unauthorized manner, used her voice in creating the Sky voice in OpenAI, as well as David Green alleged that Google used his voice in their Notebook LM podcasting product, which KVP is also handling on behalf of Google. So we're seeing a surge of these cases as the AIs are getting more realistic and advanced, and as these anthropomorphic uses are coming to light. And finally, as I mentioned before, with respect to invasion of privacy, we've seen, facial recognition startups and various AI startups get hit with lawsuits under, for example, in this case, the Biometric Information Protection Act. And it has since settled the lawsuit, but now it's prohibited from being used in Illinois for a period of time and has severely restricted use cases outside of the sort of public law enforcement context. So that was a big win for privacy rights a few years back. And I'll quickly just go through some of the other claims that we've seen, which include breach of contract. So sorts of training data are usually governed by licensing agreements and can violate both website terms of service and terms of service as agreed to by a user. We've seen some cases under the Computer Fraud and Abuse Act, which involves accessing systems without authorization. And recently in NDCal, an preliminary injunction blocked Perplexity AI's browser agent from accessing users' Amazon pages, which required, a user to allow an agent to sign in and make purchases on behalf of it on Amazon. That's still pending. I think the decision was stayed in the Ninth Circuit, so it's still pending. So curious to see how that plays out. Along with all of these claims, there are usually claims brought under California's UCL, other consumer protection acts, as well as various other causes of action, such as unjust enrichment, libel, and defamation, which commonly occur with the right of publicity cases, conversion and negligence, design defect, and failure to warn. As we've seen sort of an uptick of the mass tort social media cases, we expect to see some of these applied in the generative AI context as well, as we've seen some success with that model so far. So really quickly, what's next? Some of these barriers to copyright recovery, for example, requiring a work to be registered, have led to a wave of DMCA litigation. A lot of these defenses, such as fair use, there are some early opinions on, but have largely remained untested at the appellate level. And without sort of broad regulation and legislation, the law will be made by the courts in the upcoming years. And right now, we've seen a lot of cases focused on AI companies, but that may change and expand as people and other institutions use AI. With that, I'll turn it to Matan to talk about using AI in legal practice and some of the ethical considerations there.
Great. Thank you, Kat. And so yeah, what I want to focus on for the remainder of the presentation, other than sort of leaving some time for questions at the end, is the ethics question. How do you use AI effectively and ethically as a lawyer? I imagine that many of you are already using AI in your practice on a daily basis. And I think the uses of that are just going to increase. I don't think it's an exaggeration to say that AI has already and will increasingly change the way that law is practiced. And we're really just at the early stages of that. So there's lots of good in that potentially. There's also a lot of potential risks. So I'm going to talk about first is what are some of those risks? What are the key risks that we're seeing right now? And then how do you most effectively try to mitigate those risks, to deal with those risks within the ethical framework? And based on all of that, as things currently stand, what are sort of good uses of AI as a lawyer right now, and what are maybe some of the less good uses? So let's start with the risks. To my mind, there are currently, and this is a developing area, but at the moment, there are three key risks when you use AI as a lawyer. The first and most important is that AI can get things horribly, but very confidently wrong. I'll give you an example, sort of concrete example of that later on. But for now, the point is that AI can mess up. And when it does so, it messes up in a way that evades our usual mechanisms for finding errors. That's the first risk. The second risk is that the information that you put in sort of most widely available chatbots may not stay confidential. It could be used for other purposes. It could be used for training. It could get out to the public. And that's very important to be aware of. And the third risk is that using AI in your legal practice can lead to miscommunications with your clients and with the courts. All right, so I'm sure you've all been seeing stories like this in the news. If we could turn to the next slide, please, Kat. This is just two examples, but this is a common theme that we've seen a lot of and will increasingly see more of. Lawyers are getting in trouble for using AI in sort of the wrong ways. And the word that you're probably seeing a lot of is hallucination. What that means is basically AI makes something up. And then lawyers put that into submissions to the court, where they put into things that they sent to their clients. And lawyers are getting sanctioned for that, and rightfully so. We're also seeing stories about confidentiality issues. This is one from a little while back, a few years ago, about confidential information from Samsung getting leaked to the public because someone within Samsung put it into a public-facing chatbot. So with these risks in mind, the question is, what are our ethical duties as lawyers when we use these tools? In other words, how do the ethical rules that we're all bound by on a day-to-day basis map on to these new and developing risks? There's been a lot of discussion about that in legal ethics circles over the past 5 years. I'm going to try to summarize the sort of key points from that. But if you want more in-depth discussion, currently the sort of leading the leading pieces on that, the leading pieces of guidance on that are there's a formal opinion from the ABA. It's formal opinion number 412 called Generative Artificial Intelligence Tools. And then the California Bar has also put out a writing called Practical Guidance for the Use of Generative AI in the Practice of Law. You can find both those online easily, and they're very well written and well thought out. I'm sure that there will be a lot more. Other state bars are coming out with this, but those are the piece of guidance right now. All right, so let's talk about the specific rules that apply to each of these types of risks. And I'm going to use here, just for generality's sake, I'm going to be referring to the ABA model rules, but those also map out to our California rules as well. I believe the numbering is all identical for purposes of this presentation. So let's talk first about mistakes. That's the first risk that we highlighted. The rule that applies most directly to that, there's several, but the one that applies most directly is Rule 1.1, which is the duty of competence. Basically, the rule of, don't screw up. don't do things that fall below the standard of care. A lawyer has to provide competent, representation. What competence means is legal knowledge, skill, thoroughness, and preparation necessary for the representation. There's also the duty of supervision, which is rules 5.1 and 5.3. And what those provide is that a lawyer with supervisory authority over lawyers or non-lawyers must make reasonable efforts to ensure their compliance with the rules. In other words, it's not enough for you to make sure that you're not messing up when you use AI. You also have to make sure that lawyers who report to you and non-lawyers who report to you do the same thing, and you could be on the hook if they don't. And then lastly, there's Rule 3.1, which relates to meritorious claims and contentions. You have to have a good faith basis for any claim or defense that you bring up in a case that you raise with a court. And if you're raising something that is based on an AI hallucination, that obviously falls short of what's required by that rule. So what do these rules mean in the context of preventing mistakes when you're using AI tools as a lawyer? Here's just some basic best practices. First and most importantly, check everything independently and carefully. AI can be a very useful tool as a litigator or as a lawyer more generally. It can be a very good starting point, but you have to check it. It just may be wrong. You need to find everything you do through AI. You should, as a best practice, go and verify through some other source. Second, don't delegate your professional judgment to generative AI. Again, it can be a starting point, but it's not a replacement for what you do as a lawyer. Ultimately, it's your ethical duty still to go and exercise your judgment and figure out what the right arguments are, what the right things to do are, what the right strategy is, what the right authorities are to cite. All of that is something that's still your responsibility, no matter how impressive and advanced these AI tools become. Next, carefully supervise other people who are using AI. And that includes, if you're, for example, a partner at a law firm, that includes your associates. It also includes staff like paralegals. And this is essential and something that people forget, it includes experts and vendors and other third parties who you hire to do work for you. If an expert includes something in his or her report that is an AI hallucination, you are going to be the one who is on the hook for that. So you have to make sure that other people are doing what they should be doing as well. Next, set policies and conduct trainings. Again, if you're in a sort of supervisory position, it's not enough to just check diligently. You want to get ahead of this and make sure that everyone who you're working with is properly trained in what are proper and improper uses, and that you've got clear guidance and procedures, or policies rather, for that. Next, these next two are related. Understand how to use the technology and keep track of developments and guidance, because your understanding may get outdated very quickly. Part of the duty of competence here is staying on top of all of this and understanding how things work and what the risks are. Okay, that's mistakes. Let's talk about confidentiality. The rule that applies here, obviously, is the duty of confidentiality. This is an essential duty for a lawyer. It's covered by Rule 1.6, and it basically boils down to you must protect your client's confidential information at all costs. This is a core duty that we all have as lawyers. And the best practice for handling this is do not put confidential, privileged, or non-public information into generative AI unless you know that the tool you're using is specifically set up to ensure confidentiality and non-training. To put a finer point on this, if you just go to ChatGPT, if you just use the general tool that's available online for free, that is not a confidential tool currently. The prompts that you put in, the documents that you put in, could be used for other purposes, and you can't ensure to the level that you must as a lawyer under Rule 1.6 that those things stay confidential. Now, there are easy solutions to this, and those are law firms are increasingly, and other places where lawyers work are getting licenses to special versions of ChatGPT or Claude or various other tools, Harvey, etc., that are sandboxed. That is, that are built to ensure that everything that goes in stays in and doesn't leave. So you just have to make sure if you've got access to one of those tools, great. You can use confidential information in that safely. If not, just don't put in anything that is non-public. That would be the best practice. All right. Next, the issue of getting crosswise with your clients or with the courts. The ethical rules that apply to this are rules 1.4 and 3.3, which relate to client communications and communications with the court. And they both basically say you have to be honest and forthcoming. For the client, especially, a lawyer has a duty to promptly communicate and consult with the client. And with the court, you can't mislead the court on the law or the facts. The best practices relating to this, and I should pause, by the way, here. The issue here is not just about hallucinations or things like that. The issues are you have to be candid with your client and oftentimes with the court just about the fact that you're using AI. The first best practice I'll highlight is you need to tell your client if and how you plan to use AI and to make sure you've got your client's consent, preferably in writing. This is especially important for outside counsel, but it affects all lawyers. When you are using AI on behalf of a client, you should make sure that that client knows what you're doing and is okay with that. That's really, really important. For the outside lawyers here, again, I think it's very important to make sure that your engagement letters are up to date on this and that you review all applicable outside counsel guidelines. Again, the idea here is just make sure that you and your client are on the same page about how AI is being used, because that will avoid a lot of problems in the future. In terms of the court side of things, we're increasingly seeing courts issue certification requirements or include AI rules in their standing orders. And those basically require lawyers who are practicing before those courts, again, to say if they're using AI and to certify often that when they use AI, they are doing all the things that I mentioned earlier on, that they're independently checking, that they're verifying authorities, that they're making sure that, that they're not letting AI replace their judgment as lawyers. There's various standing orders from judges in our Northern District here. You can also see model certifications. We haven't, as far as I know, I don't think any of our local judges have done that, but in SDNY, in various courts in Texas, around the country, you see these model certifications. So be very aware, whether you're in-house or outside counsel, make sure that you know what your judge is expecting when it comes to use of AI. All right. So with those risks and with the sort of ethical framework in mind, pulling back, what are the good uses of AI as a lawyer right now, and what are the not so good uses? Again, all of this can change. This is just a snapshot in time right now. But here's what I'd say about it. First, legal research. That falls into the latter category. Legal research, even with advances that we've seen recently, legal research is a really high risk area to use AI. And I want to give a sort of concrete example. There's the sort of horror story of this. Kat, if I could see the next slide, please. So true story here. This is the first time that this was early on years ago, first time that I used a chatbot for legal research purposes. These were sort of really new tools at the time. I had a legal mal case that I was doing for one of my law firm clients. We had, sorry, Kat, if we could go back one slide before. I thought that my client had a statute of limitations defense, and I expected that the other side was going to raise an equitable estoppel response to that. They were going to say, no, it's too late. You've done something that made the plaintiff think that he didn't have to file this lawsuit, so you're equitably estopped from asserting the statute of limitations. This all sort of came up quickly. The client was asking me questions, and I needed to figure out quickly what's the legal framework. Obviously, I was familiar with this at a high level, but it had been a while I hadn't done this. What's the legal framework for the equitable estoppel response to a statute of limitations defense in California state court? And so I said, well, let's see if one of these chatbots can help me. And I put it into there. I asked, what is this? And within seconds, I got what you see on the screen here, which was, you don't have to read the whole thing. I can just tell you, a really remarkable and helpful response. It summarized for me very quickly the elements of equitable estoppel as that would apply to a statute of limitations. And it gave me some basic ideas on how it's applied. So I said, wow, that's great. Fabulous. So I asked it then, can you give me some cases that that apply this? Can you give me some California cases that apply this? And again, within a matter of seconds, it came up with this response. Here's again, 1, 2, 3, 4, 5 cases, and a quick summary of each. I looked through this. I thought the second case, Schaefer versus Berger, it's a legal mal case. This is exactly what I'm looking for. This is great. So I asked it, hey, chatbot, please give me more on this case. And it did. It gave me this response, which again was remarkable. It's very clear analysis. It gets right to the point. You know, it's the sort of thing that if a first-year associate had handed me this, I'd think this is fabulous, right? It gives you the facts, gives you the law, it gives you the reasoning, it gives you the key quote under holding, right? You see there, the court held, viewing respondents' continuing reassurances and promises of future performance, et cetera, et cetera, et cetera. I thought, this is it. This is exactly what I need. I can go plug this into the email I'm writing to the client, but let me just go make sure that, you know, from my legal journal days, let me just go make sure that the pin site is correct before I do that. So I went and I plugged this site into Westlaw. The case of Schaefer versus Berger does exist. It is in fact at 107 Calap 4th 54. All that is good. The problem is that everything else that's written here is completely made up, completely false. The case of Schaefer versus Berger has nothing to do with equitable estoppel. It has nothing to do with the statute of limitations. And this quote that you see at the bottom, this is the most important part, the most frightening part. The quote that you see at the bottom exists nowhere in that case and nowhere in any case. I looked it up separately. It doesn't exist anywhere. The reason why I'm focusing on this, and the reason why I think this is such a big risk is I've been practicing law for a fairly long amount of time. I've been specifically doing legal mal defense for a long time. I've been practicing in California courts for a long time. And when I read this nothing about this raised red flags for me. It all seemed right. The direction of the direction of the analysis seemed right. The holding seemed right. And perhaps most frighteningly, the quote seemed exactly like what you would expect to see if you were reading a Court of Appeal decision on these topics. Everything seemed right, and yet it was completely and utterly wrong. And this is what I mean when I say that AI messes up in ways that evade our usual defense mechanisms. It gets things wrong in a way that's very hard for us to detect. There's all sorts of technical reasons for this. I won't get into that given the sort of late hour, but this is just a known problem with AI. And so the takeaways from this are really, if you get nothing else, just for now, don't use AI for legal research. Certainly not ChatGPT or Claude or other sort of big chatbots. Westlaw and Lexis have introduced tools that use AI, but a recent study from Stanford suggests that even those, which are safer than the big chatbots, still get things wrong up to a third or more than a third of the time. So still massive numbers of hallucinations for those tools on Westlaw and AI. If you do sort of succumb to the temptation to use AI as a shortcut for legal research, check very, very carefully. You can use it as a shortcut in a pinch, but check very, very carefully. And make sure that folks who you're working with are doing the same thing. All right, lastly, before I leave a few minutes for questions, that's the sort of horror story. There's lots of really good things you can use AI for already. And some of the best tools are sandbox versions of ChatGPT or Claude or the like, but also specialized tools like Harvey is a model that's trained especially for lawyers and does some really cool stuff. And there's specific things for patent litigators, for all sorts of uses. So there's good things you can do. I'll list them very quickly and then I'll turn it over to questions. You can use AI tools to improve writing, right? Take a brief and make it tighter, make it better, proofread it, etc. AI is really, really good at organizing and summarizing documents. If you've got a long depot transcript and you want a quick summary of it, AI can do that really well, and there are relatively few risks there. Again, you want to check, but it's pretty good at that. You can use it for brainstorming ideas. You can plug something that I've heard a lot of my colleagues doing is you take, if you're preparing for oral argument, you take all the briefs, you plug them into one of these tools, and you say, give me the best. What do you think the judge is going to ask? What are the hardest questions I could see? And it's a remarkably useful tool for that. And lastly is document review. Again, there's a whole topic in and of itself. I'll just say my prediction personally, within 5 to 10 years, AI will be the primary tool for document review. We'll have, of course, you'll have a human looking at the results and QCing and directing, but it's totally going to change the way that we do document review. Okay, it's 10:30 on the dot. I think unless Amy says this is a really bad idea, if there's one or two questions, I think we can take those. Otherwise, I'll let you all go to the next program. Folks can put questions in the chat. Going once, going twice.
Thank you. I don't think there are any questions.